The Supreme Court room fell completely silent as Congresswoman Jasmine Crockett stood at the lawyer's table, a voice steady despite Justice Samuel Alito's third interruption within 5 minutes. 4 months, the conservative justice had been making increasingly controversial public speeches that raised questions about whether judges should take sides. Today, as Crockett presented arguments in a critical voting rights case, Alito had grown visibly frustrated with her careful breakdown of the state's position. "Congresswoman Crockett, that's not what the Constitution says," he had just stated dismissively, cutting her off mid-sentence. The packed courtroom held its breath as Crockett paused, her expression determined as she looked directly at the justice. She opened a leather folder that had remained closed until this moment, removed a single document, and began speaking in a measured tone that instantly commanded attention. What happened in the next 30 seconds didn't just silence Justice Alito. It revealed a truth that would echo through the federal court system for years to come. Before this watershed moment, Congresswoman Jasmine Crockett had established herself as a powerful legal mind long before joining Congress. With experience as a former public defender and civil rights attorney, specializing in voting rights cases, she understood constitutional law with a depth that few elected officials could match. Though she now served in Congress, she had kept her law license and occasionally took on cases of exceptional constitutional importance, including this challenge to a restrictive state voting law. Meanwhile, Justice Samuel Alito had been making headlines with increasingly partisan public appearances. At a recent Federalist Society event, he had made remarks suggesting doubt about voting rights expansions, raising eyebrows about whether he could remain fair in cases like the one before the court today. Several ethics complaints had been filed, but the Supreme Court's lack of a binding ethics code had left these concerns largely unrest. The framers understood that voting procedures needed safeguards. Alito had stated in a speech just 3 weeks earlier. Modern attempts to characterize basic security measures as discrimination would have puzzled them. The remarks had drawn criticism from legal scholars across the political spectrum for appearing to prejudge issues likely to come before the court. Behind the scenes, Crockett had been carefully preparing not just her legal arguments, but also research into the historical context of the very constitutional provisions Justice Alito claimed to be defending. As both a congresswoman and an accomplished attorney, she brought unique perspective to the intersection of constitutional law and practical governance. The courtroom was packed with legal observers, civil rights leaders, and reporters. The Chief Justice had granted extended argument time given the case's significance and expectations ran high. When Crockett approached the podium, many whispered that Justice Alito, known for aggressive questioning of liberal advocates, would likely dominate the exchange. The stage was set for what many expected would be another example of the increasingly partisan dynamics that had come to characterize the nation's highest court. As Congresswoman Crockett began her oral argument, the atmosphere in the Supreme Court chamber was charged with tension. Unlike previous lawyers who had been frequently thrown off course by Justice Alito's questioning, she opened with a clear, compelling story about the real-world impact of the voting restriction law being challenged. "Mr. Chief Justice, and may it please the court," she began, her voice confident and measured. "The right to vote is the foundation upon which our other constitutional rights rest. When 53,000 eligible voters in Jefferson County were prevented from casting ballots last November, we witnessed not just a tragedy for those individuals, but a failure of our constitutional system." Several justices nodded slightly as she established the human stakes before pivoting to legal analysis. The state argues that Article 1, Section 4 grants it unlimited power in establishing voting procedures. However, this ignores both the 14th Amendment's equal protection guarantees and the historical context in which Justice Alito interrupted, his tone dismissive. The text of Article 1 is quite clear. The Constitution gives state legislatures primary authority over election procedures. Isn't your real quarrel with the constitutional design itself? The interruption came just 90 seconds into her presentation, but Crockett remained composed. "Justice Alito, I'm not quarreling with the Constitution, but rather offering a complete reading of it. Article 1 does not exist in isolation from the Reconstruction amendments, which fundamentally changed the relationship between federal and state authority over elections." She continued by carefully explaining how the 14th and 15th Amendment specifically limited state power in the election context citing both Reconstruction-era congressional debates and Supreme Court precedents. Justice Elena Kagan nodded appreciatively at the historical context, while Justice Brett Kavanaugh made notes as Crockett built her case for why the specific voter ID provisions in question impose unfair burdens on minority voters. Justice Alito interrupted again. "These are merely inconveniences, counsel, not constitutional violations," he stated firmly. "Every election regulation imposes some burden. Unless you can show deliberate discrimination, which your evidence fails to do, these policy choices belong to state legislatures, not federal courts." Crockett calmly redirected the conversation. "With respect, Justice Alito, this court's precedents in Anderson-Burdick established that even without discriminatory intent, regulations that unfairly burden the fundamental right to vote must be justified by legitimate state interests. The evidence we've presented demonstrates the state's interest in preventing fraud is self-evident." Alito interrupted for a third time, his frustration becoming more apparent. "The Constitution does not guarantee convenience. Congresswoman, it allocates authority, and in this context, that authority belongs primarily to state legislatures." The reference to her congressional title rather than counsel raised eyebrows among court observers, an unusual break from court protocol that seemed designed to emphasize her political role rather than her capacity as an attorney. Crockett paused, her expression resolute as she looked directly at Justice Alito. "The Constitution, Justice Alito, is not merely about allocating authority. It's about constraining it to protect fundamental rights. But since you've raised the question of constitutional design, I believe the historical record merits closer examination." She opened the leather folder that had remained closed until this moment and removed a single document. "I've taken the liberty of researching the original sources that informed the Reconstruction amendments, particularly as they relate to state election powers. Justice Alito, you've suggested several times today and in recent public appearances that the original understanding of the Constitution grant states nearly unlimited authority over voting procedures." Crockett began, her voice steady but now carrying unmistakable authority. "However, I have here the congressional debate transcripts from 1869, when Congress was considering the 15th Amendment." She lifted the document, which contained highlighted sections. "Senator Oliver Morton, a principal architect of the amendment, explicitly stated that its purpose was, and I quote, to place the power of protecting the right to vote in the right hands of the federal government where it rightfully belongs, rather than leaving it to the legislative discretion of states, which have shown themselves unworthy of this trust." The chamber grew completely silent. Justice Alito shifted slightly in his seat as Crockett continued. "Furthermore, Representative James Garfield, who later became president, stated during these debates that the time has come to establish a constitutional principle that will override all state regulations that burden the exercise of the franchise, on account of conditions not inherent to the act of voting itself." She turned to a second page. "Most relevant to our case today, Senator William Stewart, who drafted much of the amendment's language, specifically addressed the question of whether states could impose procedural burdens that would effectively cancel out the right to vote. He stated, "We are establishing not merely a negative prohibition against explicit racial barriers, but an affirmative principle that the right to vote must be practically accessible to all citizens regardless of station." Several justices, including Chief Justice Roberts, leaned forward to examine the documents more closely, as Crockett handed copies to the clear for distribution. Justice Kagan exchanged a significant glance with Justice Stowey. "These are not obscure sources." "Justice Alito," Crockett continued, her voice gaining strength, "these are the explicit words of the very framers of the Reconstruction amendments, the same constitutional provisions you've cited repeatedly today. They directly contradict the narrow reading you've advocated both in court and in your recent public appearances." Justice Alito's face tightened, a flash of discomfort crossing his features as she recognized the implications. He leaned toward his microphone to respond, but Crockett continued, her voice measured but firm. "The historical record is crystal clear. The Reconstruction Congress specifically intended to limit state discretion over voting procedures precisely because they recognized that seemingly neutral regulations could be weaponized to undermine the franchise. They did not merely prohibit explicit discrimination, they established an affirmative federal interest in protecting meaningful access to the ballot." She turned to the specific evidence in the case. In Jefferson County, 83% of voters who were turned away under this law were minorities, despite minorities comprising only 34% of the county's population. This statistical disparity alone would have outraged the framers of the 15th Amendment, who explicitly rejected the notion that states could use procedural mechanisms to accomplish what they could not do directly. Justice Barrett, who'd been quietly observing the exchange, spoke for the first time. Congresswoman Crockett, these historical sources are compelling. How would you have us apply them to the standard of review in this case? Justice Barrett, thank you for that question. Crockett responded. These sources demonstrate that when reviewing voting regulations, this court should apply heightened scrutiny whenever a law results in significant disparities in ballot access, regardless of provable intent. The Reconstruction framer has understood that the right to vote is preservative of all other rights and requires special protection from procedural obstacles. Justice Alito attempted to redirect the conversation. These are interesting historical footnotes, counsel, but they don't override the plain text of Article 1, which remains with respect, Justice Alito, Crockett interjected calmly. These are not footnotes, they are the authoritative explanations of constitutional, meaning by those who wrote and ratified the amendments, and they directly address the relationship between Article 1 powers and the latter amendments designed specifically to constrain those powers. She turned to her final point. The Reconstruction amendments fundamentally altered our constitutional structure, creating new limitations on state authority precisely in the context of voting rights. To read Article 1 as though these amendments don't exist is not textualism or originalism, it's selective constitutionalism. The phrase landed with quiet force in the chamber. Several law clerks seated in the back rows visibly reacted, and Justice Thomas, who rarely spoke during arguments, raised his eyebrows slightly. Chief Justice Roberts, recognizing the significance of the moment, extended Crockett's time by 5 minutes, a rare concession that signaled the impact her argument was having on the court. Crockett then methodically connected these historical insights to the specific evidence in the case, demonstrating how the state's voter ID law imposed precisely the kind of procedural burdens the Reconstruction amendments were designed to prevent. In conclusion, she stated, looking directly at the full court, this case is not about convenience versus security as some have framed it. It's about whether we take seriously the constitutional commitment made in the Reconstruction amendments, a commitment to ensure that the right to vote remains meaningful for all citizens regardless of their race, wealth, or status. She gathered her documents as her time expired, delivering a final line that left the courtroom in stunned silence. The framers of the 15th Amendment would recognize exactly what is happening in Jefferson County today. The question before this court is whether we have the constitutional courage to see it as clearly as they did. A collective intake of breath swept through the chamber. Justice Alito sat motionless, the historical evidence having undermined not just his questioning in this case, but positions he had been advocating publicly for years. Other justices exchanged glances that communicated the weight of the moment they had just witnessed. As Crockett returned to her seat, the usual murmurs that follow a powerful argument were absent. Instead, the Supreme Court chamber remained in reverent silence, absorbing the rare moment when constitutional history, legal argument, and moral clarity had aligned with such force. The aftermath of Congresswoman Crockett's historic Supreme Court argument extended far beyond the case itself, reshaping constitutional discourse and breathing new life into voting rights jurisprudence for years to come. Within days, legal publications were analyzing what many called the Crockett Brief, not just her oral argument, but the comprehensive written submission that expanded on the historical evidence she had presented. Harvard Law Review dedicated a special issue to examining the Reconstruction-era sources she had surfaced, with note-originalist scholars acknowledging the significance of materials that had been overlooked in previous voting rights cases. What Crockett accomplished was remarkable, wrote Professor Acalamar of Yale Law School in The Atlantic. She used originalist methods to demonstrate that the original understanding of the Reconstruction amendments was far more protective of voting rights than many modern jurists have acknowledged. It's a masterclass in how historical evidence can illuminate constitutional meaning. The impact on the court itself became evident 3 months later when the decision was announced. In a surprising 6-3 opinion, with Chief Justice Roberts writing for the majority and Justice Barrett concurring, the court struck down the contested voting restrictions while establishing a new, more protective standard for reviewing voting regulations. When voting regulations result in demonstrable disparities in access to the franchise, Roberts wrote, courts must apply heightened scrutiny to ensure that the state's interests are both compelling and cannot be achieved through less burdensome means. This standard flows directly from the original understanding of their construction amendments, which fundamentally altered the constitutional balance between state discretion and federal protection of voting rights. Most notably, Justice Alito authored a concurrence rather than a dissent, a rare retreat from his previously rigid positions on state election authority. While maintaining that states retain significant discretion in election administration, he acknowledged that the historical record surrounding their construction amendments, more fully illuminated in this case than in previous litigation, establishes meaningful constraints on that discretion when regulations significantly impact ballot access. Legal observers immediately recognized the seismic nature of this shift. Nina Tottenberg of NPR called it the most significant recalibration of voting rights jurisprudence in decades, while legal scholar Richard Hast wrote that Crockett didn't just win a case, she changed the constitutional conversation around voting rights. For Crockett herself, the Supreme Court argument marked a defining moment in her already distinguished career. Though she continued serving in Congress, her constitutional expertise made her a sought-after voice in subsequent voting rights litigation nationwide. Law schools reported that applications from women of color increased significantly in the following academic year, with many citing Crockett's courtroom performance as inspiration. What Congresswoman Crockett demonstrated wasn't just legal brilliance. It was the power of bringing diverse perspectives to constitutional interpretation, explained Sherilyn, former director of the NAACP Legal Defense Fund, in a public forum at Georgetown Law. Her lived experience as a black woman from the South, combined with her legal training and political understanding, allowed her to see connections in our constitutional history that others had missed. The broader impact on judicial ethics was quite significant. 2 months after the argument, the Supreme Court announced the adoption of its first-ever binding code of conduct, which included stricter guidelines for public appearances and stronger accusal standards. While no justice commented directly on the connection to Crockett's argument, the timing led many observers to conclude that her powerful demonstration of the link between public statements and judicial impartiality had catalyzed long-overdue reforms. In state legislatures across the country, lawmakers began re-examining voting procedures with new attention to disparate impacts. Several states proactively reformed voter ID requirements to ensure broader accessibility while maintaining security, citing the Supreme Court's new standard as guidance. Conservative legal scholars, initially defensive about Crockett's approach, gradually came to recognize the intellectual consistency of her originalist methods. At a Federalist Society conference the following year, prominent originalist Randy Barnett acknowledged, Crockett has reminded us that intellectual honesty requires following the historical evidence wherever it leads, even when it challenges our preferred outcomes. Her research into the original understanding of the Reconstruction amendments deserves serious engagement from all constitutional scholars. The Crockett method, using rigorous historical research to illuminate the full context of constitutional provisions, became standard practice in major civil rights litigation. Law clinics at leading universities established projects dedicated to excavating similarly overlooked historical materials relevant to other constitutional questions. For ordinary Americans, especially in communities with histories of voter suppression, the impact was both practical and symbolic. Voter participation increased significantly in Jefferson County in the next election, with many first-time voters, specifically citing the Crockett case, is their motivation for engaging with the democratic process. This wasn't about partisan advantage, Crockett explained, in a PBS Frontline documentary marking the first anniversary of the decision. It was about ensuring that our Constitution fulfills its highest purpose, protecting the fundamental rights of all citizens, especially the right that preserves all others, the right to vote. When she returned toward another case before the Supreme Court 2 years later, the atmosphere was markedly different. Justice Alito engaged respectfully with her arguments. Other justices referenced her previous historical research, and legal observers noted that the court's entire approach to voting rights questions had been fundamentally transformed.